It's time for Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. And now your host, Bryan Nugen, estate planning and elder law attorney.
Good morning and welcome to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. I'm attorney Bryan Nugen, founder of Nugen Law, and your host for our program. The purpose of our show is to have weekly, in-depth conversations about matters relevant to folks as they walk down the path of successful aging. Our listeners will learn what it is to age with dignity and how best to protect their money. I've been practicing law for 3 decades. I'm licensed to practice in Indiana, Ohio, Michigan, and Florida, and actively represent clients in all 4 states. My practice, the attorneys, and our interdisciplinary team of professionals who practice with me concentrate on working with clients in estate planning and elder law and areas related to them, such as estate and trust administration, guardianships, and planning for those with special needs. Today's guest is Jesslyn Smith, an attorney with Nugen Law. Jesslyn is licensed to practice law in Indiana, has been doing so in excess of a decade, and is currently serving as president of Indiana's chapter of the National Academy of Elder Law Attorneys. Welcome, Jesslyn. Great having you on.
Thank you. I'm glad to be back today with you.
Today's topic is definitely in your lane, Jesslyn, especially as president of our state's chapter of the National Academy of Elder Law Attorneys. Jesslyn, as you know, 7 out of 10 people will need long-term care in their lifetime. So long-term care is necessitated when someone needs help with activities of daily living. So you'll hear the phrase ADL or the acronym ADL. Those are things like eating, bathing, dressing, using the restroom, being fed, etc. My experience has been that a lot of our clients are motivated to contact us for help when they see that a loved one or a friend of the family has lost their money, their life savings after ending a nursing home or a memory care unit, and they don't want the same thing to happen to them or to their parents. Have you had this experience when meeting new clients?
Yeah, usually clients will come in and say, well, my aunt or my uncle just went through this, and so we're concerned and we're ready now to talk about what we need to do to protect our assets and get our things in place because we're scared of what's going to happen. Mm-hmm. Yeah, so they come in when some kind of event has triggered them to start talking about this and having the conversations.
It always kills me when I hear people say, oh, yeah, we had to sell Grandma's farm, or we sold Grandpa's farm. We had to sell the lake cottage, and Grandma was in a facility for an extended period of time, and they ran out of money, and that causes them concern. And people are smart then to come in and visit about that sooner rather than later in attempting to protect their assets. So what are your clients normally asking you about when they come in?
Yeah, so when they're coming in, they're wanting to know, is there a way that I can protect some of what I've got? You know, I understand that a lot of times they'll say, I understand that, we may have this condition and I may have to pay some, but what can I do to preserve as much as possible?
Mm-hmm. Yeah. And so I use the phrase asset a lot. Right. Let's define that. When we talk about someone's assets, what is an asset?
Yeah. So an asset is more than just your bank accounts. A lot of times people think of it as the financial side of things, but it's also your vehicles, your personal property, your home, any income producing real estate that you may have. So it's more than just your bank accounts.
Right. Life insurance policies.
Yes, life insurance.
Bonds, stock, qualified money like 401k, IRA. So anything that has a value, that is an asset. So I always like to define that at the beginning of a conversation. So when I'm using that jargon, we're clear. And people forget, frankly, what assets they've garnered over their lifetime. It seems like there's always a few life insurance policies that people have forgotten about, or a bond they purchased years and years ago, and all of a sudden they realize, oh yeah, that is in the safe deposit box. I better pull that out and think about it. Are we talking about only protecting money if a client has a nursing home or a memory care unit admission? Is that the only time that we're concerned about protecting money?
No, there's also times in which you can start protecting assets ahead of time. And it may be appropriate in certain situations to start having that conversation ahead of time. Mm-hmm. Usually we look at talking about like pre-care planning. Mm-hmm. So, as you start to age, it is likely that you may have some kind of condition or diagnosis that may pop up. You also look at maybe your family's health history and mm-hmm. things like that as well to help make that determination. And so with that, then we can start to have the discussion, can we protect assets now? And what tools do we have to do that so that you're preserving it ahead of time and not in that crisis type moment and it's hit now, and now I need to rush to get this all done.
So we could be protecting money if even in an instance where someone is wanting to live out their life in their home and never leave their primary residence, we still would be having a discussion with our clients about how do we preserve money? How do we make sure that you have care in the home if need be without going broke?
Yes, right? Absolutely. And we have the ability to talk about those options for clients because there are services that you can get in the home. It is always a goal to want to stay in your home as long as possible. And so we have the ability to help accomplish that and preserve assets so that you can do that.
So I think this is the real $1 million question. When is the best time to start thinking about how to protect one's money from the cost of care as you age? And that cost of care could be in your home. It could be an independent living facility, assisted living facility, memory care unit, nursing home. But when's the time to start talking about those if you want to do it proactively?
If you want to do it proactively, you want to kind of have a 5-year goal in mind. And I say that 5-year goal because if you're looking to get benefits to help pay for your care, they state that if you've transferred or protected assets within 5 years of applying for those benefits, then there's a penalty that they impose upon you because they say you could have used that money to help pay for your care, so now we're not going to step in and help pay for it. But if that transfer happened more than 5 years prior to when you actually need to start applying for benefits and getting that care, then they can't penalize you for that transfer. So that's why I look at it as, that 5-year goal. You want to try to then to prepare those documents and start preserving the assets ahead of time.
Mm-hmm. Okay. So I think the question is, which is natural, is what is the right age to be doing this? I need the 5 years. Well, first of all, we don't have a crystal ball, right? So we don't know when someone's health may change. I have clients that are, late 50s, early 60s that are struggling with health issues and very sincere and severe health issues. I have clients that are 95 that are driving and very tuned to what's going on and completely cognitively aware. And so it really is client specific about those 5 years of time. But generally, I think people 70, 75, if they're going to try to plan in advance to protect assets and preserve them, I'd like to see these, and there are trusts that were used, but I'd like to see these trusts in place in that time frame. It makes most sense. If you look at the aging process and when people are expected to pass and your health may start to decline in your late 70s, early 80s, we really want those in place by that time. So what steps are you typically taking with your clients if they want to pre-plan before care is imminent? What steps are you taking with your clients?
Well, usually we sit down and we talk about the tools that we can use in order to do that. And usually we're talking about looking at asset protection trusts. And so with those asset protection trusts, we go through and talk about what that is with the client and what actually occurs with the asset protection trust. I think both of us kind of talk to the clients about how it's a treasure chest, and we're going to put these assets into the treasure chest, and then the trustee's going to hold that key and lock it up to protect those assets in the treasure chest.
And so it also isn't necessarily every asset that you have needing to go into that treasure chest. Clients make the decision about what's really important for them to protect. So, for example, we live in an agricultural area. We also live in an area that has a lot of lake properties. So there are certain legacy properties that our clients know that they want to be sure to pass to the next generation. They don't have an intention of using that during their life. They may be enjoying it, but they don't have the intention necessarily of selling it or getting rid of it during their lifetimes. And they know that that farm was purchased by my grandfather, and my father had it. My mother inherited it. Now it's my turn to think about. I want to protect that and pass that on to my children. So these trusts that you're mentioning, Jesslyn, enable us to do that. But a client may say, hey, I want to make sure I have immediate access to certain things. So outside of that trust, we're going to leave checking account, savings account, other funds, other resources, other assets that they want to have immediate access to. And there's nothing wrong with that. No, that's up to them. Again, they make the decision. What assets do we want to be sure and protect? Because these trusts are powerful devices, and they work well if they're in place for 5 years or more. But it is a little bit more involved. It does require us to, continuing your analogy, Jesslyn, it does require us to rely on somebody else to assist us with gaining access to those assets, for the beneficiary of the trust, giving them that key to get into that treasure chest when necessary for the beneficiaries of the trust that you designate. But in my career, that 5 years has changed. At one point, it was 3 years, and now it's 5 years. So I've been practicing long enough to see changes, and changes may again be on the horizon. I think that we see Medicaid constantly looking at ways to trim out folks that may not be appropriate to be using benefits. And so one way of doing that is to make sure that we have a longer look-back period, or a longer time that those trusts need to be in place for your assets to be protected. So really, the sooner the better, but to be aware of those and have that discussion with you, Jesslyn, about what it is that the trust does for you, the purpose of it, how it functions. And I found that my clients, we can have a discussion in one meeting, right? However, the client, it's a lot of information. So the client may need to come back for a second meeting to bring a child with them. Boy, this is a little bit more involved than I thought it might be. I want my kids to be involved and hear this presentation as well. Do you have any objection to seeing a client once, twice, as they're making the decision about what's best for them?
No, not at all, because I really want them to make an informed decision for their situation. And if they need to have other individuals in that meeting with them, or they need for me to explain it to them again so that they understand. Because the last thing I want a client to do is to sign something and not really understand what it is that they're getting. Because then that's really not accomplishing their goal. They should understand what it is they're doing.
Right.
So, yeah, as many times as I may need to meet with them to make sure we're meeting that goal, I want to do that.
Sure. I find myself diagramming the trusts and making sure that they're following how the diagram works, how the trust functions. And people learn differently. Some people learn by hearing you explain it to them. Some people learn by reading. Some people learn by seeing that diagram and recognizing how it ties into what they want to get accomplished. I see myself, and you probably do as well, Jesslyn, as an educator. My job with my clients is to educate them about what it is that we're talking about, and then to educate them about how that ties into their goals and what they wanted to get accomplished. And I'm hopefully doing that for them, educating them and explaining to them the process so they're confident in what decisions that they've made and how to use that trust as they move forward. So there are some assets that regrettably can't go into the trust, the major ones being qualified monies. If you could explain to our listeners what qualified monies are.
So qualified money is money that you've set aside that hasn't been taxed yet. So once you start tapping into that, you start to get taxed on it. So it's an investment tool that you have that hasn't been taxed yet.
All right. So 401ks, 403bs, IRAs, those types of things, unfortunately, traditional IRAs and inherited IRAs can't go into the trust. Those have to stay out.
That is correct. But I also tell clients, that it's good for the attorney and the financial planner or advisor that they may have to have a conversation and discussing maybe options of more aggressively taking some of those funds out while they're still alive so that they can use those funds and it's being taxed at maybe their lower tax rate than if when the kids, say, inherit it. Because usually if they're going to be inheriting that, they're likely still working and receiving income, so they're going to be taxed at higher rates on that money as they're taking it out.
Sure. Well, and so the phrase required minimum distribution, RMD, we hear that in relationship to IRAs. And so generally, what that's saying is based upon the amount of money that's inside your IRA, based upon your age, there are tables that the government puts out that says you have to draw down so much of your IRA every year. That's a required minimum distribution, but it's not a maximum distribution. So you could speak with your financial advisor, speak with your CPA, your tax preparer, about how much more can I take out above and beyond this RMD that is keeping me in my same tax bracket, but is there more money that I can pull out? So sometimes when we're funding those trusts, those asset protection trusts initially, we may actually draw a little bit more down that year from one's IRA, not increasing their tax rate whatsoever, so that we can more fully fund that asset protection trust with the monies that you have. So let's take this a step further. If we have an individual that we anticipated they're being able to meet the 5 years, and we felt that it was appropriate for them when we established that asset protection trust. We've gone through it. It's been set up beautifully. We've funded it. And then changes happen. So someone's health changes, their cognition changes, they've had an accident, and we don't make our 5 years. So how do we look, this is a question that always comes up with my clients. What happens if I don't make the 5 years before I need help? So what's our approach then?
Yeah, so kind of going back to the analogy of the treasure chest, the trustee has the key, to be able to access that, to be able to distribute it to the lifetime beneficiaries that you've named in the trust. And not trying to get too overcomplicated on that, but the lifetime beneficiaries then can return a gift. We can return assets to reduce a penalty that may have been created if that's sufficient. But also we need to look at the timing of maybe when you went in, because maybe if it was 4 years after, we may want to go ahead and pay for a year of care to protect a larger chunk of assets.
Sure.
So it's kind of a timing piece with it too, to decide how are we best going to reach into that treasure chest if we need to, or do we wait and continue to pay? Did we leave enough assets out? Maybe you still have enough in your IRAs that were left out to pay for the care for that remaining year and a half. So we look at that, and so we've got to look at the situation,
Sure.
and it's different for everyone.
Well, you've said a mouthful there. I think it is different for every client. And when I have people coming in saying, oh, my neighbor did this, or my cousin did that, or my sister did this, well, I don't know that neighbor, cousin, sister's situation. It is unique, bespoke to each client, what we're accomplishing for them. So I think those that I didn't used to hear people talking about the 5-year look back, the 5-year look back. People are now hearing the 5-year look back, and they think that that's magic. It isn't magic. We're looking at what have you taken out of your name without getting something in return over the past five years, 60 months. And so there isn't a pro rata. It doesn't. If you have given something away within 5 years, you have established these trusts within 5 years, and we're to our earlier discussion, you're getting close to the end of the 5 years. It isn't a situation where I've got 10% of the 5 years left, so only 10% of those assets that you transferred count. Nope. The whole thing counts. There is no pro rata division based upon time that has gone by. So we really do want to hit those 60 months if possible. But I appreciate your saying, Jesslyn, that if in fact we don't hit those 60 months of time, that we still may have some techniques that we can use to protect their assets. And it is a cost-benefit analysis. So to your point, maybe we want to privately pay for 6 months of care. Maybe we want to privately pay for 18 months of care. If that means that we can protect a larger block of funds. And that's a meeting that they should be having with us so that we can take a look at what their anticipated cost of care is, how long ago we set these trusts up, how much is in there, and what can we feasibly do.
One of the nice things, too, is that, we also may be able to offer them possible solutions to also maybe keep someone home longer, too, where the cost of care is cheaper, to help push us through that 60 months as well. So, it's very important in having that conversation with us so that we can offer them, the potential solutions that they may have in order to actually make it there.
I do like to point out, so when we talk about these trusts and giving the key to the treasure chest to a third party, typically children, doesn't have to be, but typically, that people get nervous about, it's set in stone. So it goes into the trust, and it went in as a CD, and it's going to be in the form of a CD, from here until the end of time. Or I put the big house in. What happens if we want to downsize? What happens if we want to move to sunny Florida and buy a condo down there? So let's talk about that. Are they able to, within that trust, is the trustee, the key holder, are they able to shift assets inside that trust so that if property goes in as real estate, does it always have to remain as real estate?
No, it doesn't. They can. As the trustee, they have the power to invest and move the assets in other options that may be more beneficial. So
if the child is the trustee holding the key and mom or dad leaves the primary residence, they move into assisted living, the children are able to, the trustee, the key holder, are able to sell the home and then to invest that money with the financial advisor.
Absolutely.
I find that to effectively represent our clients, we're typically working with the team of the clients. And when I say the team, I mean normally their CPA, tax advisor, their financial advisor, whomever they're investing with, if they are in fact investing with someone, and the law office. And we all are part of that, working for the best interest of our clients and making sure that we're preserving their assets and that we're doing what we can for our clients in achieving their goals. So that I think is an important point as well, that it isn't just the attorney that's shouldering this responsibility, and that it's a team of people that are part and parcel of that process. So one of the questions that I normally hear as well is, if I've established this type of a trust, and the children are holding the key, right? The children are the ones that are managing the trust now. The children may be a beneficiary of that trust. Is there a tax consequence to the children if they're the ones that are holding the key, if they're the ones that are drawing money down from those trusts? Are those trusts structured in such a way that there's going to be a tax impact on the children?
If the trust is prepared correctly, it should be what we like to call as intentionally defective, which means that it's still considered a grantor trust, meaning you as the client who created the trust are the one being taxed on that.
Mm-hmm. And that's a good thing for the children.
Correct.
As you were saying earlier, the children are typically in a higher income situation. They may still be working, so that if they were to be taxed on the assets in that trust, the income that's produced by the assets in that trust, they may be paying tax at a higher rate. And these trusts are not to be used lightly, and you want to make sure that as an individual looking for this type of work, a client looking for counsel, they want to speak with someone like you, Jesslyn, that understands it. Not too long ago, I had a trust in that another attorney had prepared, and the trust indicated that no payout from the trust could happen once the person moved into a nursing home. And they had told their client that, this will protect your assets. So you can manage the money, you have access to the money, you can manage the money, your fingers can be in this trust as long as you want it to be. And I've written this trust so that when you go into a nursing home or have a memory care unit stay, at that time, your access is stopped and you can apply for benefits such as Medicaid. I'm shocked, right? When I see that, it doesn't work. I feel bad for the client that they've spent money on that trust, and they have the impression, and have had the impression for years, that their home was protected, the farm was protected, and it really wasn't the case. Have you come across situations like that as well?
I have, and it's a very difficult conversation to have with the client, at that point, because they have believed for so long that their goals were being accomplished, which is why I take it very seriously in making sure the clients understand what we're accomplishing for them and that we are preparing the right documents for them.
So when we are with our clients at Nugen Law, when the trusts have been established, we're having one-on-one meetings with them, one-on-one meetings with the children, explaining the process. We also bring the client back in a few weeks and meet with them again to make sure that the trust is funded properly and that it's an ongoing conversation with them to make sure that everything is set up right. We want them to have a good experience with this. We want them to be able to make those 60 months successfully. And that open and honest conversation with our clients is essential for us to be able to achieve that, for sure. When we hear horror stories about a parent or a grandparent having to sell their farm or the lake house, depleting all their savings to pay for a long-term stay in a nursing home, did that really need to happen?
No. There are solutions even after you've gone in which you can protect assets. You may not be able to protect a larger chunk of it, but we can still protect quite a bit. but it's having that conversation with us and what tools we can offer in order to accomplish that.
Sure. So pre-planning is better, but it's never too late. We always can protect assets, even if you didn't use that asset protection trust we were discussing. So thank you, Jesslyn, for joining me and our listeners today. You've provided some invaluable insight. If someone would like to meet Jesslyn in person to discuss estate planning or another elder law matter, I encourage you to call 260-925-3738 or email us at help@nugenlaw.com. Thank you for listening to Life Care Planning with Nugen Law and to our guest, Mrs. Jesslyn Smith. I look forward to next weekend, Saturday at 9 a.m. for Life Care Planning with Nugen Law here on WOWO. Enjoy your weekend.
You've been listening to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. For more information, log on to nugenlaw.com or email help@nugenlaw.com. Nothing stated in today's program should be considered as legal advice, should not be considered as having created an attorney-client relationship between show host and guests and any listener. Nugen Law is not liable for anything that happens as a result of a listener relying on provided information as legal advice. The content is for informational purposes only.